Well, in a domestic violence case, bond is different than in a non-domestic violence case, in that when someone is arrested on a domestic violence charge, there's a 48-hour hold period that is put into effect automatically before a monetary bond will be set. That's to sort of give a cooling off period, is what the intent of the law was. Now, that law is often misused by people attempting to game the system, and it can be used to get someone arrested, put them in jail for 48 hours, while the accuser cleans out the house or the apartment or the trailer, takes off with the kids, sort of get a 48-hour head start, if you will. And so we fight to prevent that whenever someone calls and they've just been arrested on a domestic violence charge. But the 48-hour period logistically works like this. There's a 48-hour period, no bond is set, and the person is held up to 48 hours or until the first available judge comes onto the bench in court in that county or district. Now, in northeastern North Carolina, unlike metropolitan areas like Raleigh and Charlotte, people accused of domestic violence are sort of at a disadvantage because we don't have courts running every day. And we don't have a judge sitting on the bench all the time, basically, like they would in Charlotte or Raleigh. And so I would bet that in northeastern North Carolina, where I practice, in those 11 to 13 counties that I work in, I bet people spend a higher percentage of the 48 hours in jail than do people perhaps in Charlotte or Raleigh, simply because we don't have the access to a judge that people in the big city would have.